I'm thinking we're gonna, I just seem to be, I love Jacksonville, but I just seem to business office.
I know, it's,
Come on now.
we come to them all the time. They just sit.
Looks like you had a very successful tournament. Rained right at the end, but yeah, just right at the end. But it was a huge crowd. Looked like it was great turnouts, great tournament. And a nice guy winner.
Yeah. Yeah, unbelievable.
The way, where we are, folks, is, yeah, please, go ahead. Yeah. Where we are is, this morning the city has asked, they have a proposal they'd like to start with this morning. I kind of had outlined yesterday that that's what I expected we would do. So I had some language on a particular issue, but I'm going to hold that because I know that's part, likely to be part of a larger proposal. So we're just waiting, as I understand, for copies to get down here, and then we'll get going on. And so I really don't want to get into arguments on issues until we get this in front of us, which may stimulate the conversations.
Arguments? No arguments.
Discussions.
Discussions.
A little intense.
Yes.
Randy Wise told me not to get mad today.
That's right.
I'm gonna, my expressions will be much,
I think everybody's done
we've done a good job.
great. I had the over-under in fist fights at 3, and so far I'm way under.
Thoroughly.
No, you guys have done very, very well. All right, what I'm going to do now.
Here they are.
Surviving.
Chris, I'm going to let you hand this. Let's hand these out, and then we'll take a look at everything, and then the floor will be yours to present your proposals, and then John will hear from your side, and then we'll hear back from y'all.
Is there another step too?
And I don't know if you have this where you can put any part of it. It probably help with others. Thank you. Got it. All right.
Thanks, Chief.
Yes, everybody have a copy of that?
Yes, sir.
Okay. You will distribute these. Okay.
Go ahead.
Okay. Carol is distributing these to the public as well. This is up on the board. So, Senator, what this is this is sort of a summary of what we have already agreed to, plus a city's kind of counter proposal as it relates to attempting to wrap up governance and current employees. So just sort of first for review, the parties have reached agreement on new employees. These are the new employee modifications that were part of the mediation settlement agreement and endorsed by the Retirement Reform Task Force. The one alteration, of course, is the computation method for the early retirement penalty, and I have attached the spreadsheet that Mr. Gravy put together we've all agreed to as part of this. So that's just sort of review. We've also agreed to remove from consideration Task Force Recommendation number 13, which relates to the general employees and correctional officers' pension plans. So that's been removed from consideration. And then we've also reached agreement on 3 governance matters, 3 Retirement Reform Task Force recommendations. Number 1, which is related to the Financial and Investment Advisory Committee. Number 2, which is entitled Ethics Certification and Disclosure Requirements for Investment Managers and Advisors. And number 6, which is entitled Actuarial Standards, Transparency, and Disclosure. Again, those are 3 governance matters on which we have reached agreement. Now, to kind of move forward on other kind of governance and current employee matters. Obviously, there's been a lot of discussion about the subject of who controls the fifth member of the Police and Fire Pension Fund. The mayor's spoken a lot about this and how this is a priority for him to have an appointment as the mayor who's held accountable for the taxpayers for these issues and the importance from his perspective of having that appointment. We also know that it is of great interest to members of City Council. In fact, Council President Gulliford and Councilman Pressenbenny have scheduled a notice meeting for tomorrow on the subject of the Police and Fire Pension Fund, specifically on the possibility of putting an item on the ballot for voters to weigh in on who ought to have control of the fifth member. So this is obviously a matter of great importance to the elected officials who ultimately will decide these matters. If the city were not to insist on the fifth member, we'd have to have some very clear standards to ensure accountability and proper qualifications, and to ensure that we have a financially sustainable employee benefit plan kind of moving forward for current employees. So with all that in mind, the city will not insist on having recommendation number 4, which is the city appointment of the fifth member, if we can get agreement on the following matters in exchange for the JPFPF agreeing to the following. Number 1, clear qualifications for the city appointed trustees and the fifth trustees. The language you see in front of you on page 1 of the handout is very similar to the language that the task force recommended, and again applies those qualifications and criteria to both the 2 city appointed trustees and the fifth trustee who would be selected by the other 4. And it notes that they will be persons with professional financial experience and or public pension experience, governance experience, institutional investment experience, community experience and wisdom, or comparable professional training, knowledge, and experience and expertise. So that is to establish clear qualifications for not only the 2 city appointed trustees, but also the fifth trustee when the other 4 are selecting them. Also, as part of this proposal, the JPFPF would need to accept the City of Jacksonville's proposal on current employees, which we made at the initial meeting on May 6th and reiterated, I believe, yesterday. We were talking about that. Those are the changes we put up on the board previously. We would also need the JPFPF to agree to the mediator's language on the use of the Office of General Counsel. And when I say the mediator's language, I mean the language that Senator Smith proposed last week, which has been a document that's been forwarded around as well, that has a big X on the front in terms of those provisions that don't apply to the use of the Office of General Counsel. We would also need the JPFPF to agree to Task Force Recommendation number 7. We have made some relatively minor modifications to that. And John, I'll be able to give you for the afternoon session a redlined version if that would be helpful.
Thank you, Chief.
Sure. But just to kind of reiterate how this would read, it would now read the selection of any future executive director / administrator. And by the way, John, we just changed that to reflect what your current title is.
Thank you.
Of the JPFPF will be governed by a professional process subject to Florida law, in which the candidate will be selected by the board using the City Employee Services Department search and selection processes and, if necessary, using the assistance of an executive search firm retained by the board. A salary and benefits survey will be conducted prior to advertising for the position in order to establish a compensation level comparable to funds of similar size and complexity to the fund. In addition to the requirements of applicable law, candidates will be required to have a minimum of 5 years of pension administration or institutional investment experience, expertise in the oversight of investment portfolios, and a degree in finance, economics, accounting, or related area of study from an accredited university. Comparable experience administering the activities of a state or local public pension plan will also be considered. Candidates who are CPAs or who have a JD, MBA, or CFA degree will be preferred. So that is a modification, slight modification of Task Force Recommendation number 7. In exchange for not insisting on city appointment of the fifth member, we would also require the JPFPF to agree to Task Force Recommendation number 8, which again is slightly amended as kind of set forth here on page 2. And just to kind of read it into the record, that reads, upon the selection of the next executive director administrator of the JPFPF, the aggregate compensation of the executive director administrator shall be determined in accordance with a market analysis of comparably sized public pension plans provided for in recommendation 7 above. The city and/or JPFPF shall assure that any future executive director administrator and/or senior management employee is placed in either the city general employees pension fund or a defined contribution plan with the JPFPF employer contribution subject to the limits of federal law. The JPFPF's current senior staff pension plan will be frozen as of the close of the pay period immediately preceding August 15, 2014, and following that date, no further benefits will accrue under the senior staff pension plan. Benefits will be distributed to senior staff pension plan participants after closure of the plan, as if such participants had been enrolled in the Florida Retirement System Special Risk Plan or by the purchase of annuities as permitted by law. For any senior staff pension plan beneficiaries who are currently JPFPF employees, benefits will be distributed following termination of employment. The next provision is Task Force Recommendation number 10, which is entitled in their Task Force Recommendation as Return to Collective Bargaining. We have retitled it and changed some of the verbiage so that this proposal, again, which would be part of the package that the city would need in order not to have the appointment of the 5th member, would read as follows. Negotiation of pension benefits. The benefits as set forth in the restated agreement enacted in 2011-64 and subsequently amended in 2003-303, 2003-1338, and 2006-508 shall be modified as set forth herein and remain in effect through September 30th, 2017. Following the implementation of these benefit modifications, the JPFPF shall not negotiate changes to pension benefits or impede the bargaining agents of the representative employees from negotiating changes to pension benefits. So that is a modification of Task Force Recommendation number 10, similar subject but different title and different verbiage. The last two are the final two governance recommendations of the Retirement Reform Task Force. It's Task Force Recommendation number 11, which is entitled Consultation Among Parties. This is one we had essentially agreed to before, just with some minor wording changes. Again, how this would read: consultation among parties. The city and the JPFPF should consult on an ongoing basis related to their performance under this agreement, public records, open government issues, and other matters. Senior representatives of each should meet monthly to discuss matters of importance to either, and both parties should proceed in a spirit of good faith and cooperation. In that regard, the parties should make available to each other on a continuing basis all information that is necessary to assure their mutual understanding and success. The city and the JPFPF should endeavor to work harmoniously to enforce their respective obligations hereunder under this agreement and applicable charter, statutory, and ordinance code provisions, and to avoid obstruction of their respective rights. Meetings will be in accordance with applicable federal, state, and local laws. And then Task Force Recommendation number 12, which has simply been rephrased here to reflect how it would appear in an agreement as opposed to a Task Force recommendation. Expression by charter and ordinance. The city and the JPFPF agree to support and promulgate this agreement through appropriate revisions to the charter and the ordinance code. So again, just to sort of summarize, we've reached agreement on new employees, we've reached agreement on several governance provisions. What this would do is, in order to take a balanced approach to make sure that the city has the assurance on accountability and transparency, given the large amount of taxpayer dollars going into this process, and to ensure that we have long-term financial sustainability in terms of benefits, notwithstanding the strong feelings of the mayor and city council members about control over the 5th member, the city is willing to retreat from that in exchange for acceptance of our proposal on current employees and these other governance provisions, particularly including the language as to the qualifications for the 5th trustee that I have outlined in this proposal.
Before I turn it over to you for response, could I ask some questions?
I wish you would.
Okay. I want to go to number 5, number 5, and I haven't been able to compare it, in what way to number, Chris, if you tell me how number 5 stacks up. I know the original language in 5 that was it had the mayor language, which would have reflected, so this omits the mayor language, which reflects the proposed change to 4.
Sure.
Does this change anything else from what we had as 5?
It makes 2 changes, and again, for the afternoon session, I'll have a red line version so people can see. But what it does is the original proposal referred to appointments by, I believe, the mayor and the city council. This changes this to say the city. Obviously, that's for the mayor and the city council to determine how those appointments are made. It's not really a subject for the board and the city to determine. So it refers to the 2 city trustees. It also adds the provision because, of course, in the task force recommendations, there was a recommendation that the 5th appointee be appointed by the mayor, approved by city council. This now makes it clear that these qualifications would apply to the 5th member of the trustee as appointed by the other 4. So when the other 4 appoint that 5th member, they would now have clear criteria and qualifications with which to make their appointment.
Then on number 8, and this may be for you or somebody on your team, benefits will be distributed to senior staff pension plan participants after closure of the plans if participants have been enrolled in the Florida retirement system, special risk, or by purchase of annuities permitted by for any senior. Above that, there was the way in which there had been some discussion, if I remember right, there had been some discussion about where we would put the new administrator and whether or not that administrator would have an option of going into a general employee's pension plan. And then I think that's where the 401A option, well, this language, well, I guess what I'm asking is, or a defined contribution plan with the JPF employer contribute subject to the limits of federal law. Is that essentially saying that the 401A or that option is not available, or is defined contribution plan broad enough language to cover that or not?
To the extent that a 401A qualifies as a defined contribution plan, then it would qualify under this language. This is actually very similar language that was in the mediated settlement agreement as it relates to that.
I just want to be clear, because I think actually the other day their proposal had been to put that language in there, and what you're saying is, to the degree that a 401A is a defined contribution plan within the limits of federal law, then that is an option that would be available.
Correct. This would give the option, 2 options for future executive director administrators, either to be in the general employees plan or to be in a defined contribution plan subject to the limits of federal law.
To back up for a minute, in what way is number 7 different than 7 was? I'm trying to do a side-by-side, and that's almost impossible to read that rapidly. The proposal number 7 that you had advanced.
Sure.
I think which was from the task force.
Sure. And of course, some of this cleanup is related to the prospect of taking it from a task force recommendation to putting it in a provision that would be in an agreement. Yeah, it essentially makes 2 changes to number 7. Again, you'll have the red line for the beginning of the afternoon session. Change number 1 is Mr. Keene had asked to have clarity that the candidate would be selected by the board. So we've inserted a clause that says in which the candidate will be selected by the board using the city employee services department. So we've made that clarification based on Mr. Keene's comments. The other piece it does is there had been a provision in the second to the last sentence that in addition to talking about the years of experience, the educational requirement, the expertise and investment oversight, there had been a clause that said something to the effect of or comparable work and experience. I can't remember what the exact language was. That, and again, just to be clear from the red line, that language was deleted so that there's absolute clarity on the years of experience, the expertise required, and the educational background required for the successor administrator.
And just to make clear, that would be almost a third of the last line. And
right.
Right. So the clause omitted the clause which was
Correct.
Comparable training experience.
And
is the
experience,
omitted.
correct, yeah. So that's, in other words, there'd be a period now after university.
Got it. Okay.
So again, so to establish absolute clarity in terms of years of experience, expertise required, educational background required, it would eliminate that. It would also change the word under the previous provision, the word comparable experience directing the activities of a state or local public pension plan will also be considered. Just again, in the interest of clarity, we changed the word from directing to administering, just to be consistent with the rest of the language in that paragraph.
On paragraph number 10, as proposed with the new language, first of all, this is probably something you guys are very familiar with and I'm not. Explain to me what 2011-64 and those various other, are those prior council amendments to the 30-year agreement?
So 2011-11-64 is the enactment of the restated settlement agreement, the so-called 30-year agreement. That legislation and the agreement it implemented was subsequently amended 3 times. In 2003-303, 2003-1338, and 2006-508. That legislation and those 3 amendments currently define the current benefit structure. So again, what this is saying is these benefits, the benefits as set forth in those agreements are hereby modified in the ways we agree to them and remain in effect for the 3-year period we discussed through September 30th, 2017, and that following the implementation of those benefit modifications, the Police and Fire Pension Fund shall not negotiate changes to pension benefits and shall not impede the bargaining agents of representative employees from negotiating changes to the pension benefits.
Right. Again, this probably shows that I know much less about this than y'all, but let me ask a couple of questions on this. I want to first of all go to the issue of September 30th, 2017. You're saying that the benefits as set forth in this agreement shall remain in effect through September 30, 2017.
Correct. So from a period of October 1, 2014 through September 30th, 2017.
Is it your view that this language that the 30-year agreement as amended would expire entirely on September 30, 2017, or would be subject to amendment but no sooner than September 30, 2017?
Our position is that any benefits provisions, and there are obviously other provisions which we need to discuss and are not sort of subject, but the benefits provision, in accordance with Florida law, would be in effect for that 3-year period from October 1st, 2014 through September 30th, 2017. That comports with the 3-year requirement that is part and parcel of Florida law.
Now, you have here that the board shall not negotiate changes or impede the bargaining agents. Let me just ask this. The board has independent responsibility and fiduciary responsibility, as I think you guys have all set it out and explained. Just for a moment, I want you to assume that the collective bargaining process, that the police representative or the fire representative sit down and they negotiate a benefit proposal, and that the city, I'm just using this hypothesis, the city and the unions agreed to some benefit proposal, some contribution that may affect contribution, may affect, I mean, anything could be negotiated on the issue of pension. That comes back and it is agreed upon by the city and the unions. What happens if the board in its responsible position says, we believe this is not, we believe that the collective bargaining, either the benefits bestowed or the contribution affected no longer, that would affect the soundness of the pension plan which we oversee. I've never quite understood this in the collective bargaining process, and I'm raising it again. John and the board have or John's successor and the board have a responsibility. What do they, if they say we're not going to accept this, is that a problem?
If I may, this is the law. Okay, the city negotiates it, understanding how much is this going to cost and the impact on the budget. The PFPF takes the information in their actuarial fund, and it's math. What they do is math, and they say, this is what it costs.
Right.
The city has to pay it. It's that simple. If they want to get in the middle of a policy decision, which I don't recommend as a fiduciary, then they have 3 minutes at the podium and they have the discussion in their public meetings. But the city has every right to do that. The job of the trustees is to be at the podium saying, we need more money when you do this. And here's our actuarial report done conservatively. We need more money. Their job is just saying, now that you've made that deal, you need to pay for it. Nothing more, no right to tell us, because they can compel us to do that. They can compel us to pay for the deals that we've negotiated. That's their sword, not entering into a policy decision about whether we should give less rich benefits.
One thing I want to add to that, if I might. This provision is entirely consistent with how most other police and fire pension funds in the state of Florida fulfill their responsibilities, which is a fiduciary responsibility to maintain the financial soundness of the fund and leave the negotiation of benefits to others. If you talk to Mayor Seiler in Fort Lauderdale, or Mayor Buckhorn in Tampa, or Mayor Dyer in Orlando, or other mayors in cities where they have police and fire pension funds, there's a fairly clear distinction between the role of the fund, which is the financial soundness of the fund, and the role of bargaining agents, which is to determine the benefits of the fund. This simply provides that same clarity which exists in similar entities around the state.
And the police and fire collective bargaining representatives, their respective agents, have historically waived collectively bargaining over pension benefits in the city of Jacksonville. Is that an accurate statement?
I would say it's accurate to say they have waived them in this instance. Mr. Chapman has letters from both the JFF and the FOP, which we've distributed, where they waived them. I don't know that I would say that it's historically true they have waived them, but they have certainly waived them in this instance.
The concept, Senator Smith, is the same as for FRS. Did 1,100 unions waive for the past 10 years their pension rights, or were they just, that's what they were, and so people went on and bargained their salaries knowing that that's what they had? Because for 10 years, 1,100 unions did not bargain pension in the FRS. The FRS went to change it, they bargained pensions. And so that's a right that the bargaining agents have. Apparently wisely before, everybody let that go while they focused on other matters. But they certainly have the right 3 years from now to look at this and say we want to get back in the game. And that's an important matter. They're elected by the police and fire membership to do that. And if they waive, they waive. They're entitled to.
I'm only troubled. I'm not troubled.
Yeah.
I'm only asking the questions because I really think the FRS is not a really great example in some ways. I mean,
legally.
It is, but it's not, because I actually, one of the few things I may have some knowledge about is I actually was stuck on the end of trying to figure out how you overlay that, because the reality is that one of the things that happens, particularly with like the FRS, is the idea that there's the long-term plan for benefits, long-term contribution. How are we going to, the very things that you guys are talking about, how are we going to deal with the challenging issue of unfunded liability? We're not going to. The reality is there's very little change that can or does ever take place on a 3-year cycle in a pension. And when I said historically, and correct me if I'm there, I remember the conversation being during the mediated settlement negotiation that it had been, that the 30-year agreement, I won't say was in lieu of, but had essentially been substituted for, and that during that period of time, pension benefits had not been negotiated by the respective police and fire representatives. Is that inaccurate?
Well, I can tell you that historically there have not been actual negotiations over police and fire benefits with the unions. That hasn't been because there have been efforts by the administration. In the past, prior mayors have actually made efforts. It's just that document had been in place and there had not been negotiations. Whether you would say that they actually waived them or not, I wouldn't want to put words in the union's mouth, but I will say at this standpoint, they just haven't been done. Well,
I think it's evident that historically, for some reason, we have the creep from the original settlement of management to the fund actually negotiating benefits, which is a problem for a fiduciary. I mean, that brought us 38% funding. So clearly a change needs to be made, which is why the mayor's proposed these changes. And I think it's better for everybody. The fund gets back to managing their money and focusing on that. And the unions in a changed environment have the clear right to negotiate their pension 3 years from now.
And all this is, and just to be clear, what this is attempting to say is, here's the term of these potential benefit changes, and that following that term, there's nothing that impedes the unions from exercising their right to collectively bargain these benefits, which is a right that inures to them under the law.
Well, my biggest problem, once again, it doesn't matter what my problem is, I'll let John address those issues, but I do have a conceptual difficulty, because really what has happened here has historically, and I'm not a conceptually difficulty with the idea of the fiduciary responsibility, it really has to do with the overlay of an agreement between y'all and the board, which directly addresses kind of the collective bargaining positions of the IAFF and the
Oh, I have that.
FOP.
Yeah.
And what's been my problem with that from the outset has been, wait a second, I don't think it's been that the unions come in and try to change the pension benefits, because I know that hasn't been the case. I think what the union's concerns were, as I recall it, was that they were concerned that, well, the city comes in, the city now, we think we've entered into, or we think that there has been now a settlement of benefits that inure over time that ought to deal with the unfunded liability issue, ought to stabilize the new employee and old and current employee situation. And in fact, what you're saying is, well, yeah, but this, in exchange for that, we've only stabilized it until the city comes back and says we want to change it in 2017, 3 years henceforth.
Well, just to be clear, that wasn't a date we just picked out of thin air.
No, that's the 3 year.
Comports with the 3 years.
That no collective bargaining agreement shall require, can require continuation for a period of time greater than 3 years without the parties having a window of opportunity for which they can reopen certain subjects. And that's
The best way, and let's focus on abuse, if we thought of two agreements, maybe ultimately when we draft them, we'll do that for the purpose. It really is to give everybody the right to focus on their rights. When you blend them together, everybody will remain vulnerable. They will remain vulnerable. The unions waived this time. They didn't waive forever. They can't waive forever. They may, the economy...
wait for 30 years.
No, they can waive each 3 years for a compilation of 30 years. They sure can. That's their right. And I think none of us can see 3 years from now whether they will want to engage for a better pension or not. I mean, this is pretty, and for the fund, because clearly it hasn't worked because we're not funded where we would. So the fund should have the focus of, yes, city, you've negotiated these, now this is what you need to fund it. And I think it preserves everybody's rights completely. Nobody's giving anything up in this scenario.
11 and 12, I'm sorry.
Just practically speaking, look, one of the other issues here is one of the key concerns raised by city council members when the previous mediation settlement agreement came before them was the length of the term, particularly as it related to benefits, because they were concerned that it did not comport with the 3 years set forth in state law. So, we have to obviously take into account that as well. But you were moving on to 11.
Yeah, and correct me if I'm wrong, 11 and 12, and I'm looking back at my notes, trying to do it at the same time. I think 11 and 12 are very similar to things that we had, in spirit of things, had already previously.
That is correct, and these are really only changed from the task force recommendations in such a way as to make them appropriate for a potential agreement. For example, on number 11, Mr. Keene had expressed concern about having the date 2014 in here, so that was removed. He had also expressed concern about not having a reference to some charter provisions and some prior agreement provisions, so we addressed that in a broader fashion just by saying these meetings would be in accordance with applicable laws. So those changes are relatively minor and sort of cleanup items to what we talked about before. Same with number 12. 12 is also, as you were correct, in spirit with some language that was in the MSA, and also very similar to the retirement reform recommendation, which essentially obligates both the city and the police and fire pension fund to support the agreement and to promulgate it through appropriate revision to either the charter, if appropriate, or probably in most cases changes to the ordinance code.
Okay. John, do you want to respond to this now? I know you also had some unfunded liability issues that you may want to raise, and we may get a discussion of everything going at once. I mean, it doesn't matter to me, but I'd like to give you an opportunity to raise questions or issues here that are concerns to you. Obviously, from the city's perspective, this change in 4 and 5 means that the status quo as it relates to the manner in which, with some guidance being given as to qualifications, that the status quo for the selection of the 5th member would remain in effect. Against that backdrop, which I think is from their perspective and from the mayor's perspective, a large movement, and I just want to hear your reaction to this. But I don't want to ask any questions you want and give any reactions you want to. We're trying to move this thing forward, and it seems like this is a kind of a package designed to move this section forward.
Thank you very much, Senator Smith. It's my understanding, Chief, this is a new package. This is the deal, all of it.
If this were accepted in the form that it's been presented, this would add the resolution of governance and current employees to the resolution we already have on new employees.
Okay. All right.
Can I, because I didn't get this, what happens to the unfunded liability issue?
Well, we haven't addressed that yet.
I know that, but is that, when you said this would be the deal, were you thinking this?
No, this is
short of that. Got it. Okay, go ahead. I'm sorry.
the deal on
I just want to make sure nobody's getting misled. We're walking away from unfunded liability.
Well, no, we're not going to do that. Let's go back to number 11 and start working backwards.
Yes, sir.
I think it's the second sentence from the end. The city and the JPFPF should endeavor to work harmoniously to enforce their obligations, Didn't you just tell me that the council president and a council member are preparing to have a meeting to do something that could be in conflict with this and contradictory to the terms that we're trying to reach?
No, I told you they're having a meeting to illustrate just how strongly the city council feels about that particular provision. So if we were to not have a change in the 5th member, we would need to have some very clear and stringent balance to make sure that the city's goals are achieved. So I was just letting you know just how strongly they feel about that 5th member issue and why, if we were to step back from that, we would need to have, again, that strong balance there.
Right. Well, we know how some of them feel about it because they've introduced a local bill twice, so we're aware of that. We believe that the introduction of those local bills is directly contrary to the cooperation provision that's in the current settlement agreement. And I'm not asking you to agree to that premise, but careful reading of what it says, they shall not obstruct each other's rights. Now, I just want to make sure we understand that. And I want to switch back to the 5th trustee for just a minute. Since the inception of the current board process, our first 5th trustee was the president of a local bank. Our second 5th trustee was the vice president of the Florida National Bank. Our third 5th trustee was a former division chief appointed by Mayor Austin. Our fourth 5th trustee and the current 5th trustee is the former sheriff and president of Edward Waters College, Nat Glover. So in the period of time from 1986 through now, the majority of the trustees, the elected police officer, the elected firefighter, and the 2 people appointed by the city have always sought and selected well-experienced professionals to occupy that fifth trustee slot. And what's a very important role. We need somebody in there that understands what it's all about. While we agree that this is what the trustees have done historically and what we'd anticipate they would do going forward, there is a problem with putting the requirements for the fifth trustee into a written document because the Attorney General says you can't. And while we could make some kind of side letter or something over here that says the board is committed to having competent and qualified fifth members, the Attorney General in the North Miami Beach case said that the City Council cannot set the requirements for the fifth trustee. I just don't want to run afoul with the Attorney General's.
So, John, is it your position that when we put language that was almost identical to this in last year's mediated settlement agreement, and then put that in the ordinance code, that runs afoul of that Attorney General's opinion? Because this is almost identical to what we agreed to, or very similar to what we agreed to in last year's MSA. It's also virtually identical to what the task force recommended with your participation in that process.
Oh, we agree. We certainly agree that, and we think it's good language, and we think it's good guidance, and we think it's good business and good government. I'm just pointing out, while we have the top squad here from the general counsel.
So your issue, let me ask you, so your issue isn't really about the qualifications that's laid out here. I just want to be clear. Your issue is having it in writing, right, stated in this document that you think would go afoul based on the decision that was made by the Attorney General in Miami?
I think, Mayor, let me refine what you said a little bit. Our issue is we probably could adopt a board resolution or something like that outlining the commitment to use these educational and background guidelines, but the Attorney General's opinion does not cause us a lot of grief because we've always had well-qualified fifth members.
I have a different question on this, and mine may be entirely practical. And let's assume that the city came in and they tried to put a specific recommendation of a limit on the fifth member, and I believe that the city probably could not do that on its own because I think, but I don't know that. It doesn't matter for purposes of my thought on this. Every person that you've named, and most of which I've either known or known of, and frankly, every person that you would consider, given the long experience of this board, would be persons with professional financial experience and or public pension experience, government experience, institutional investment experience, community experience, wisdom, or comparable professional training, knowledge, and expertise. I mean, it seems to me that all this is some, and if we just took the language and said, if you had that concern, will be, and you put should be, I'm just throwing this out.
Or will continue to be.
Or, I don't see anything there. I can see circumstances where you could put limits on the selection of a member that an Attorney General could step in and say, wait a minute, that's inconsistent with the requirements of the governing statutes and general law. I can see that. It seems to me that this language, and particularly if you said it will be, or it seems to me, because I remember this conversation, this is almost virtually identical to what A, has always been the case, and B, what the MSA had agreed to before the board ever looked at it. So I guess what I'm saying to you is, if you put language in there that said should be persons with professional what would be the basis of the challenge? That somebody was wrongfully selected because they didn't meet that? I mean, how would you challenge that?
Particularly this language
Right.
specific of an agreement, yeah.
The AGO's opinion, which by the way is not binding on us, and they have a 50% batting rate, which isn't bad. But the AGO's opinion is on the selection of the fifth person, not in any way, shape, or form trying to impair the board's ability to reach an agreement on minimal qualifications, which actually can be an advantage to the board as it has a mixture of city-appointed and their own appointed people. And so so long as those qualifications, as you pointed out, are of this ilk, this is an advantage for the board, and that case would be inapplicable as a whole, because the board certainly has the power to do that.
So John, so the language that you would be comfortable with, so there's no challenge, would be that it will be, continue to be, use the word continue to be, would that be, is that what you're looking for, to show the historical position of the board's fiduciary responsibility? Is that what you're doing?
It's a very good concept, it's one we strongly support.
Okay.
Historically and personally.
All right.
But we just need to wordsmith it in.
So that's all, let's stop right there. That's why I want to make sure, Mr.
No, go ahead, go ahead.
So,
It seems to me we're about
will
to-
continue to be, meaning it's always been, that's what your concern is. And it's not like we want to set a precedent. So you want to make sure the board has always been able to bring on qualified people. So continue to be would be the verbiage that you would like to have right there versus will be, but continue to be.
Maybe we ought to take the words out of the Attorney General's opinion, and it says, however, this would not preclude board members who are choosing the fifth member from considering the particular qualifications of any potential board member. We think you should have all of those. Maybe you could put that as comfort language in. I don't know.
We're happy to take a look at it, but
You'll take a look at it. I don't read that AG's opinion. I can see from the AG's opinion, and I absolutely can see a circumstance where if someone tried to misuse it too narrowly or to construe it in a way that kind of guide it, I can see that. What I'm saying here, these are qualities that you've always had, qualities that I can't imagine you would, which one of those qualities you say, this is not important for this position. Everybody would want each or some combination of those qualities, and you've always had it. And it just seems to me that now I'm just from a practical point of view, and I've known an awful lot of attorney generals, and I've even worked with a number of them. I just can't see what the basis would be for a public statement that says we are looking for, as we always have, or continue to look for people who have these qualities. It seems to me that's just a statement to the public, giving them some assurance that we're not going to, this isn't going to be an inside deal by which a brother-in-law gets appointed or something like that. We're going to look for the kind of qualities, experience that you would generally expect anybody to do in making this selection, and which this board has done for virtually all of my adult life. I mean,
and just give guidance to the other four, so they've got some, clear direction on the criteria they need to observe.
Come back, John,
So we'll
with
come
something
back,
to give you.
we'll come back with some language.
Yeah. But that's a follow-up
Okay, yes, sir.
to the chief's comment. We did raise this down in Gainesville last year.
Yep.
So, and
I think I even read the opinion.
right. And here's the question. Just then we'll get off of this. The city attorney for the city of North Miami Beach says, do sections 185.05 and 175.06(1)(a) Florida statutes preclude an amendment to the city of North Miami Beach Police and Firefighters Pension Plan ordinance to add criteria for the selection of the Police and Firefighters Pension Plan Board's fifth member. The short answer is the city of North Miami Beach may not by ordinance add criteria for the selection of the Police and Firefighters Pension Board fifth member. What I want to do is try and get some words worked around there so that the intent as proposed by the city this morning, which has been historically the way we have operated, is guidance going forward in the future. That's all we want.
I think we can work with that.
We can work with that, I think that's.
What else, what other concerns do you have here, John?
Well,
I think 6 is off, so you're at 7.
had a question here about number 8.
Well, before I leave this, number 7, the change that was proposed there, as I'm reading it, so that we're just clear. The only difference is between this and the recommendations of the task force was the task force had the phrase "or comparable training experience," and the city's essentially saying, we really think that's a little softer or squishier than we want it to be. We'd like it. We want a commitment to these kinds of qualifications. That's the change.
Actually, just to reiterate, 3 specific changes. 1, we've inserted the by the board language.
I'm sorry, yeah.
Yeah.
That was their
right.
their
Which was John's
their
recommendation.
suggestion earlier, to make it clear who selects the future administrator. It eliminates, as Senator Smith says, that clause "or comparable training and experience," so it ends that sentence after the word university, and then changes the word directing in the next sentence to administer. Again, this will all be seen on the red line we give this afternoon.
Okay.
My question is the one I wanted you to react to is your comparable.
Well, comparable is still in here. It says comparable experience administering the activities of state or local pension plan will also be considered, and that's fine.
You're comfortable with that?
Right.
Okay.
And that previous words that we had the squad over here in employee services help us write the job spec for it. So, I mean, this is not something we did all by ourselves.
I'm fine.
Okay, so
Down number 10.
7 looks good. 8.
8, I'm sorry, I apologize.
It appears that the city's proposal today is to close the senior staff pension plan on the payday preceding August 15th, which had been identified before. And what's going to happen to the incumbent between that day and the day the incumbent leaves employment? They're going to be into the either general employees or the 401A that we're talking about, or what?
This doesn't address that other than to say that the pension benefits that the incumbent has accrued during the incumbent's current service at the JPFPF would be distributed in the manner discussed here. It would not be distributed until the incumbent is no longer employed at the PFPF. That prevents the situation where someone's obviously getting both a salary and a pension at the same time.
Okay. But you can see there's got to be a place for the incumbent to go between now and December 30th of 2017.
Well, is the incumbent comfortable that that provision provides or should provide that it simply prohibits both taking the pension and the contingent salary?
It's clear it does that.
Okay.
And that's fine.
Okay.
Wasn't ever anybody's intention, I know.
All right.
Number 10, we're going to have to talk some more about.
Okay.
And I think number 11 and 12, those are good words that we've long agreed with.
Thanks, sir.
And we'll just look to be sure.
And 13 is out.
13, I believe they withdrew.
Yeah. All right. So let me summarize just for a moment. You didn't give me one other thing, and that's probably my fault that I didn't ask about it. I'd like to go back to number 3 for a moment, which was, and this is not a pride of authorship. I didn't know this, obviously wouldn't have known that this was, but essentially I made a proposal. You guys have taken my proposal as a moderator and put it in there. I know, John, that you'll want to talk to your counsel, I'm sure, about this, but let me try to tell you what I'm shooting for here. And I have some other language that we may want to talk about. As I have listened to this, what I'm really shooting for on number 3, having had an opportunity to hear Cindy's comments for the last couple of days on this. I have told everybody that I have also been in contact with Bob Foster regarding this, because obviously his firm does the pension and retirement-related work and all that, and so I didn't want that issue, and was actually, I think, named in the task force recommendation, actually the firm was, and I had some concern with doing that. What I really had decided, am aiming at, and if this doesn't do it for you, John, I want to work towards this. Both of you have very strong commitments to working together, and frankly, the division of work right now appears to be working. That is, you're pleased with what those things that you've had done by the general counsel, and the city's acknowledging that outside separate counsel is appropriate for the broader retirement pension related matters. There are issues going to arise as to when you may not agree and they may not agree with you regarding what the parameters of their counsel and your counsel would be, and I know that those can arise, and they have historically arisen on occasion. What I've tried to do here, and maybe, and I throw this in to see if it would have any, make this better to anyone, I'm not, by agreeing to this, to work and be guided by this, I'm not asking either side to waive or relinquish their legal position on if conflicts arise or they are unable to agree after meeting. I don't want either side having an advantage on that. I'm really trying to maintain what seems to be, at least now, a workable status quo. Not only a workable status quo, but a working status quo. In fact, so much so that the firm was even commended in the task force's study, and so was the Office of the General Counsel. So if this language doesn't work, and it was not to give either side an advantage, it is to try to, and I will tell you that I had, and I throw this out for both sides' consideration. Let me grab something here. I'm getting to where I start looking at my desk. I had come up with some proposed language, and I want everybody just to consider this, and I'm not going to give you the whole proposal now because I don't want to make this more complicated. But please consider if something along this was added, John and Cindy, and to your counsel, because if we added the following last phrase, would it make it any more acceptable to both parties? In the event the parties should be unable to agree regarding the selection or the use of separate legal counsel, nothing contained in this provision is intended to be, nor should be construed as a waiver of any rights either party may otherwise have under the Charter or Florida law.
Fine by me.
Do you have that in a written form?
I do.
Review?
But I didn't want to but I just, I'm going to have somebody block out the rest of
Gotcha.
it. I had another proposal. Given this proposal, that last thing, what I'm trying to do, I'm trying to get both sides to say, okay, this is how we're going to work. But if it doesn't work in the future, there's a time when it doesn't work, both sides maintain whatever their position is. And I'm going to give you the classic. I know, I've heard it from both of you. Heard it from Bob at the table when we last. It is, right now things work, but there may be a day when the city comes up with an opinion that you think is dead wrong, and you think the board has a right to challenge that. The city says you don't. OGC prevail. That's probably going to be for somebody wearing a black robe to decide. This wouldn't give either side an advantage on that argument. But this would give you, this is what you are all actually now doing. This reflects what you are actually now doing. But it doesn't constitute, in the event you can't make it work in the future sometime, and you just, then what, neither side can go in and say, this gets us over the hump. No, that'll be decided, whatever rights the law gives you, the law gives you. Whatever the charter gives you, the charter gives you. But this would work in an interim. That's all and I will have this blocked out and get it to you in a few minutes. So it's just that my proposal would be the same language, and I know you have some concerns with that language. What I would propose is see if by adding that, you guys could live with this as a provision.
So it would be this proposal with that supplemental
sentence
language, yeah.
as the last sentence, the sentence I read in, and I'll X out and give you both a copy to look at. Now, so.
John, any feedback on it?
You want to read what he?
Yeah,
I'm just curious.
Yeah.
I'll get it to you.
We're here to help.
I've gone through this several different ways, and I was wondering if I could get that in front of you. I'll tell you what to do. I want to go ahead and get this discussion.
I can type that up and email it to my secretary.
I'll just do it. I'm going to do it really high tech.
Well, I mean, we can, in a matter of 5 minutes, Carol, put this in a document and print copies.
Could you do that? Have somebody, that sentence right there.
I'm sorry, the sentence at the end?
Yes.
Carol.
Want to take a break while this is happening?
Oh, yeah.
Yes, we'll take a break while this is happening. We're going to break, folks, for 10 minutes. So give everybody time, and maybe somebody has time to get on the call, make a phone call or anything like that. Please bring that back as quickly as you have it, and I'll go ahead and distribute it. And for purposes of public records, Madam Court Reporter, this is the language I'm having drafted that I just read, which is in the event the parties should in the future be unable to regarding the selection or use of separate legal counsel. Nothing contained in this provision is intended to be nor should be construed as a waiver of any rights either party might otherwise have under the charter.
Give you something on that, and he may have something else to say. That's to say this instead of you here.
And so this morning, I did not realize all we have to do, everybody agrees with all we have to do is we have to post opening time.
Well, we simply noticed an opening time and did not notice a closing time in any way. So, yeah.
So whatever calendar we have internally, if we're running over, I'm just going to keep going.
Yes.
I don't know that.
Okay.
Okay.
Sure. Well, now I understand that. Okay.
Yeah, that's true as Congress and true as state Okay, that's fine, thank you. No, I didn't want to say that. I think where we were going to start.
We have brought some red line versions.
Why don't you pass those
Sure.
out?
And let me indicate what these are. First are the 3 governance provisions to which we've already agreed. That's the Financial and Investment Advisory Committee, the Ethics Certification and Disclosure, and the Actuarial Standards Transparency and Disclosure. I just wanted to make sure it was everyone had these. We've agreed to them. That the court reporter had one for the record. And the only changes we've made to these is they were recommendations. They would now be part of an agreement. So there's obviously a couple of word changes that come along with them being part of an agreement, but very minor and scribblers in nature. So there's one for you and one for the court reporter. And Carol, could you distribute these others? Yeah, everyone down here has one. You can make sure John gets one. John, did I give you one?
Not yet.
Okay, Carol will do that. And then the second set of red line documents we will distribute is kind of some tracks very closely, obviously, with what we did this morning. These are city recommendations on the general counsel language. It shows sort of striking the provision related to the 5th trustee. It reflects our discussion this morning on the qualifications for the 5th trustee. Reflects the presentation this morning and the agreement on number 7, which is the selection of the executive director administrator. the provision on the future administration of the JPFPF that we discussed this morning, a proposed city modification to number 10 to track the moderator's suggestion this morning, which is the negotiation of pension benefits provision, and then numbers of the sort of minor changes to numbers 11 and 12. So if I can, give a copy to Mr. Smith, Senator Smith, and to the core reporter, and a copy to everybody else.
Got him, here's a copy. Thank you, Chief.
We'll have Carol contribute when she comes back. I think as a starting point here, John,
Yes, sir.
okay, go to this one that we just handed out, which is number 3, which is almost entirely red line now. This one just simply says, while the charter gives the JPFPF the authority to voice out of the council, the JPF never mind it, Johnson. I want to pass it out. Let's see if I can get over this for a moment.
Yeah, that's fine.
This was just something I worked out over lunch. I have no earthly idea. Once again, pride of office doesn't matter at all. Just read along with me and see if this may, or maybe just some movement here and there, because all the subjects. The parties agree that while the charter grants the JPFP the authority to employ separately the council, the Office of General OGC is the proper source for legal representation on routine matters, consequences of the record, and the like. The parties acknowledge and agree that separate counsel is and will be necessary regarding investment, investment, and the retirement matters. The JPFPF and the OGC shall consult on needs for separate counsel for other specific purposes. The parties agree that the current legal counsel structure of these are reasonable and appropriate. In the event the parties should in the future be unable to agree regarding the selection or use of separate legal counsel, nothing contained in the provision is intended to be or should be construed as a waiver of any rights either party might have under the charter or the law. Does that capture what we talked about this morning?
I believe it does.
I'm comfortable with this if you are.
All right.
Okay.
With the exception, Madam Court Reporter, that I put in, that I, much like I did in high school, cannot seem to make my verbs the right tense, we will correct that. And I'm going to say that this is, that number 3 is TA, meaning that right now we've got something we can all live with, and move then to, John, at this point, I think my next thing I wanted you to do was you be prepared to, so to be clear, now 1, 2, and 3 are off the table. 4, 5 are on the table, but we have some sense of agreement on 4 and 5. 6 is off the table. 7 and 8 are very close. 9 we're not dealing with right now. 10, I think you've made another proposal, but we'll get to 11 and 12 are agreed to, and 13 is pulled. So, John, with that summary, I think part of what needs to happen for this kind of package to work is for you to react to the where you guys are on the proposed current employee modifications, the 4 silos that I had in front of me, and with everybody's feel free to do this because I'm a little warm. We're going to move to the retirement benefits. We have the task force proposal. You remember when that was up in front of us, and I think you have a copy there. Thought maybe we'd get your reaction to that and see where we are on current employee modifications, because that's obviously central to our being able to get off of it's tied into the governance proposal, which the city has made this morning and appears at the top of page 2. So John, I'm going to turn it over to you for a few minutes and get some reactions from you and any offers you have and any counter proposals you have.
Need longer arms, don't we, buddy? It's a long arm, don't we?
Okay, this is a 513 current plan member supplement contribution. John, why don't you go through, and could we get that up?
As soon as she gets back.
It's like, this is from its King Dave, it says 51314 up there.
Next one.
Next one should be right there, yes. Okay. John, why don't you explain what we're looking at?
Some
Additional copies for the public?
I'm gonna hand that to you.
I got it. Okay, John.
We are proposing for the current employee pension design to increase the allocation of chapter funds over the next 4 years by 62.5%. And that will be allocated in the next budget, 2014-15, 4%, which raises the total contribution from the members directly from their pay, as well as from supplemental chapter funds, to 15% of payroll, reducing in 2015 to 3% additional, which makes a 14% total payroll contribution on behalf of the current employees. 2016, 2%, which is a 13% total, and 2017-18, a 1%. The member contribution will become 10% following the return of the wage reductions as the city had previously described. And no matter when that happens in those next 4 years, the commitment of supplemental chapter funds will remain. And then in 2018, a 2% reduction in 2019, and that we will also establish a member share account effective 10/1/14.
All right, I'm going to ask some questions because this is a little different than I've looked at or looked. What you're doing here is you're proposing that you guys would supplement, you would add 4% chapter funds next year. Taking the total.
4 more.
Four,
7,
four,
4 now,
right.
11.
Yeah,
4 more.
4 more above the 11.
Yes.
So you would run it up to 15%, then you would run it to 14, 13, and 12. The member contribution, whenever it occurs, will go to 10% as long as it coincides with the reinstatement of the previous budget pay rollback, right?
As was discussed at the mediated settlement.
Yeah. I got that. Now, what I'm not following what happens in 18 and 19 and 19 and 20 on your proposal.
The current 4% chapter supplement that's on line 2 of this page would be reduced out in a 2-step theory.
In 18 and in 19.
Right.
Is that 2% each time?
Each time. That would eliminate the 4% on line 2 at the top of the page.
And so in 2018 and 2019, what would be the amount the employee is paying? 10%?
10%.
And what would be the amount of supplement being received from the board?
2%, 4% to start in 18, and goes down to 2%, and 2% in 19 and 20, and in 20, it's 0. and all the money will then flow into the share plan.
Okay. And describe for me, and I know we talked about this before, but describe for me the share plan, or for them, and describe for me the share plan and how you, what the benefits of that are and how that would, in your view, be structured.
The share plan is a type of defined contribution plan for our members. In Miami, for example, since they had it on the board the other day, the money comes in from the state. It's divided by the number of police officers and firefighters, and each one gets an equal share. It's then invested for them. Then when they leave, that DC plan is cashed out for them, and away they go. Here in Jacksonville, instead of using the share plan money in that manner, we have used it historically to pay for supplemental benefits. As we move forward, those benefits are being reduced for new employees, and so no share plan money can be utilized to help offset that cost. And as we move into 20, there will be virtually no one left who has an enhanced benefit that we would be required to use chapter money to pay for.
And I may be mixing apples and oranges, and correct me if I am. Before I leave that, can you, in just kind of raw dollar numbers, tell me, because I know you knew before, what is the total allocation of new dollars to the plan that would be paid in each of these years, represented by the 15, 14, 13, 12?
Each one of those percentages represents about $1 million, $1.25 million, $1.5 million. As the payroll base increases, the value of that would also increase.
And Joe, are you comfortable that those numbers are about right? Okay. So 15% would translate to something close to $19 million. I'm just doing this off the top of my head. $19 million. Is that right? No.
I think it's better if you separate out the employee's salary deducted contribution.
Yeah, that, so you would take out the 15. You would take out in year 2014. Under this, you would be taking out 7, is what you would take out.
Be contributing an additional $6 to $7 million.
That's
depending on what the actual
new dollars from you. That's probably a better way to do it. You're right. But okay. Joe, let me just finish one thought, and then I'm going to let all of you ask all the questions you want. I want to kind of lay this side by side for a moment. This plan that you've advanced as a counter-proposal by the board, how does that stack up, or does it stack up, to any of the issues that were discussed in the proposal that was made by the city yesterday as it related to COLA drop? I know it directly addresses, it does address directly the employee contribution proposal. It's a counter-proposal on employee contribution, I get that. And you are, seems to me, both in agreement that 10% will be the final figure when the reinstatement occurs. So I'm trying to, I understand that. How about the COLA issue and the drop issue, as those were addressed by the city yesterday on the 10-year or less than 10-year employee?
So these millions of dollars will be in lieu of implementing those 2 reductions.
So these dollars will go away at some juncture. As I get it, they're gone completely at 2020?
Correct.
Okay. So the proposal that you have would be that you would put, that the board, by that I don't mean, the board would put up these amounts for these years in lieu of these changes that are recommended for current employee modification.
Correct.
By the city. I just want you to, now how does this stack up against the proposal that was agreed upon financially in the MSA?
New employees, current employees were not addressed in the MSA. They were left whole.
So but under this, you are reducing your contribution because of the new employees, correct?
Correct.
You're not contemplating any change to current employees.
This proposal that we have here before applies only to current employees.
I said that backwards then. The reason for the reduction in the latter years, as I understood it, is the supplemental benefits will no longer be forthcoming. Did I say that wrong?
You talk about the last two reductions?
Yes.
Yes, sir, because they're no longer extra benefits. They've been granted to the other employee groups.
Okay, so that really doesn't have anything to do with the new or the changes off.
Just leaves the money there for another 6-8 years.
And just then, one further kind of question is at least for me, is this proposal, does it contemplate that these would be and remain the contribution levels for all of the years between now and 2020?
Yes, sir.
And the employee contribution, it does not matter if the employee contribution, and I'm just making this up, if the wage loss was supplemented next year, offset next year, and it went into effect, you would still provide the same.
It does not matter when the employees receive the return of the salary reductions, and then the second round, which would then push their contribution up. This money would be committed all the way to 2020.
All right, Chris, I'm going to kind of put it on your side of the table.
Sure.
I've asked too many problems.
Sure, let me just ask a couple of questions just to clarify. I take it this additional contribution would come from the other half of chapter funds that is now going to pay the supplemental benefits, is that right?
Yes.
And so rather than using this to help pay down the unfunded liability in the event the city were to put in extra money toward the unfunded liability, you would be instead proposing to use these monies to hold employees harmless from...
It supplements the contribution going into the fund. Mm-hmm. And you can say it's for either A, B, or C. Mm-hmm. Millions more is going to be flowing into the fund.
Mm-hmm. How are you, so if you use 4%, and we go with our number, which is, let's just say it's about $1.3 million, just to round it off per percent.
Round it down to $1 million.
Okay, even $1 million. Although that certainly hasn't been our calculation in the past. It's been higher than that.
I was just talking about for ease.
Yeah, sure. So how would you propose, even if it's at or just over $1 million in year one, that would eat up basically the entirety of the additional half of chapter funds. How would you propose to set up a share account in year one if all of those additional, virtually all of those additional dollars are going to the plan itself?
We would be using some of the reserve chapter funds we have.
And so this proposal would be in lieu of any changes to any of the benefit modifications we have proposed, in other words...
For current employees.
So this would mean, in effect, you're rejecting the COLA provision, you're rejecting the drop provision, you're rejecting the final average compensation provision, and the employee contribution provision in favor of this.
It means we're offering this as a substitute.
Mm-hmm.
Yeah, I take this as a proposal, a counter proposal. I don't take this as, because I think that there are discussions on how these can intersect with one another. Sure. Because you were talking about, Chris, maybe I'm wrong on this, but I think that your plan just for reduction alone, unfunded reduction, contemplated $4.5 million off to supplement the $20 million additional dollars that the city, is that?
The plan we proposed as we were speaking exclusively the unfunded liability was that if the city is to put in an additional, say, $40 million a year, that they would put in an additional $4.5 million, which is right now the amount of the extra half of chapter benefits.
Now, hold that thought for a minute.
Yeah.
Under this provision, if you were to come up, and if this were to be accepted for the funding levels like this, knowing that we have an unfunded liability issue that we're out there talking about, the unfunded liability, the way the city was proposing to address it was at this additional level of its ARC plus 40 matched by your 4.5. Would you be able to do this and the 4.5 annually?
You could do both, but you could take these dollars here, and instead of flowing into the main fund, you could redirect them into paying down the unfunded liability, if that was what the city would like better.
So may I ask another
Yeah.
question?
This is all about everybody understanding what we're trying to do.
This proposes to establish a share plan as of October 1/14. Under any of the scenarios, either primarily the task force scenario and the one we presented, the fund wouldn't get to an 80% funded status, essentially a doubling of where it is now until 2028. So just so I'm clear, the board is supportive of starting a member share plan, which is in effect an additional benefit, now prior to the fund being at or near the 80% funded level. Board supportive of that?
You didn't mean 80%, did you?
No, what I meant is right now we're at 40%.
Right.
Under the scenarios we've run, the date the fund would reach 80% funded status, which is considered in the healthy range, is 2028. I'm just wondering, knowing that it would take an additional 14 years without any additional benefits provided to get to that healthy status, the board is nonetheless in favor of starting a new benefit as of October 1?
No. The board's in favor of establishing a share plan effective October the 1st. The amount of funds that would flow into it off in the future would be dependent on our other obligations here, whether there's any residual funds to go in. If there's not, there's not.
Okay, so if I can follow up with this for a second. Under the unfunded liability proposal, if it were to be accepted, one by which I think you had a 2028 calendar for 40 additional above ARC million, matched by 4.5 from chapter funds. I believe it was half of the chapter funds was how it was identified. If that happened, would that take priority over funding the share plan in those years?
Yes. And
So the share plan might be there, and in those years wouldn't get any money into it if it was exhausted by the obligation to reduce the unfunded liability first.
that's right. But now, this contribution here is, we're not owing to that last item we talked about, that you keep putting off the financial piece.
The unfunded.
So, yeah, the unfunded. We're not onto that yet.
I understand.
But these dollars here could be directed over to there. So there's not three halves.
That's what I'm getting.
Yeah.
You're right, I am jumping ahead, but I am jumping ahead only because I know that unfunded liability is an issue both sides are very serious about.
And we'd be glad to apply all this money directly to the unfunded to push it down. Or it can go into the base benefit fund, as this proposal is. It could go in either place.
But as I understand it, from this proposal, what you're proposing is an increase so that there is to use your model, an increase in the employee contribution without employees feeling it in their paycheck. So
Right.
you can't have it go to both places. You can't have an increase in the employee contribution and applying this money to reduce unfunded liability.
It can go in either place you want it. That's what I just said. We could either have it come in as a supplemental contribution, or we can apply it directly to the unfunded. Either way.
Following up for a moment, when we were having these discussions this morning, and I know nobody's followed this more closely than you, because you follow it as long or longer than anyone else here. One of the issues that the council, my recollection is, one of the issues the council was very, had difficulty with under the plan was current employee, I think you guys have used the shared responsibility, shared sacrifice, whatever it is, but the council talked a lot about, and I'm paraphrasing, it didn't go far enough, the MSA didn't go far enough on shared employees, and they believed to put it all the weight on the new employees, none on current employees, and therefore that was something that they had difficulty with. Now, Do you agree that that was one of the things that was talked about as a reason we were unsuccessful in getting the MSA passed?
I certainly agree that's one of the things they said. I mean, certainly they said
Right,
that. You know, I don't
I'm
agree.
I'm not asking you to read minds, I'm asking you.
I don't
that
agree
was-
with all of their statements, but that's one of the many they like to say over and over. No question about that. But in the recent Times Union story on plan design, after they did their exhaustive research, they found out that the Jacksonville Police and Fire Pension Fund is not one of these Cadillac plans. It's not even the mid-ranger, not even a nice Buick. It's down here in the Chevrolet level. And to reduce the benefits of an already plan that's not even average to the other police and fire plans that the Times Union selected for the survey, not something we said, go look at this one, go look at that one. We didn't tell them to go look at Palatka and Hilliard. You know, they chose who they went and looked at. And when they looked at them, they found out that our benefits were below the median of other plans. And so
But some of that is also, I mean, I'm not arguing the point with you, but you agree that whenever you do that, you weigh that in light of a whole lot of other factors. And for instance, I mean, yes, Tampa has benefits that Jacksonville doesn't have. Yes, Tampa has an index that results, not always, but generally results in a significantly higher employee contribution rate. I mean, all those, I mean, you can't.
Well, and also just to be fair to the Times Union, what they did is they looked at the benefits that were negotiated for new employees going forward as part of that article. So I think we have to be very careful what the standard of measurement is there. They also didn't look at the comparability with the Florida retirement system, which in many ways is the system we compete with the most. So we might just want to be careful how we're
But I understand what you're saying. I'm just saying.
and we agree that there's differences in Tampa and Miami.
Sure.
Both of which have a share plan.
Both of which have significantly higher employee contribution rates.
Well, in Miami, it's 10, and we're going to 10.
Well, yeah, that's right, but it's been, yeah, you're right, it's been 10 for some time, and when here was
11.
11 total, but the employee, I think, was 7.
Right.
Okay. Other questions from your side of the table or reactions? Because go ahead, then I need to see if we can move a little bit here on. When we talked about the drop plan, I'm just going to use that as an easy example yesterday. The drop plan that changed for current employees was simply a change which was from a specified rate to a range that reflected actual performance. Right?
Correct.
I mean, that's what the drop plan.
That's the proposal.
That's the proposal. What is it about that, and I'm just using that as an example, what is it about that proposal that would be found, and that's one that would apply to drop for all current employees, right?
All undropped employees.
All, yeah, correct. All current employees not yet in drop.
Right.
Now, for all current employees not yet in drop, if that were to be the provision as opposed to 8.4% being guaranteed, that the contribution rate would be, that the accrual rate would be based on actual rate of return, what would have been the actual rate of return this year for the employees?
In this case here, they'd get 10.
That's what I'm saying. So I know that if we went over time, there's years that wouldn't be the case. But the fact is that if the city's proposal were enacted this year on drop for the accrual rate, the drop rate would have been higher under the city's, the accrual rate would be higher under the city's proposal than it is today.
Correct.
And obviously knowing that could go on for a number of years if the market performs well, and then there would be years it wouldn't do well. What is it about that idea of a stated rate as opposed to a range that reflected more accurately market performance. A stated range that, at least now and for the probably immediate future, a stated range which is below what the accrual rate would be by market performance.
The 8.4, which was a deviation from the 8.5 actuarial assumed rate of return, started in 1990, and between 1990 and I think it was 2004, as the market was going up, we managed to pay the 8.4 and accumulate an additional $60 million. We made more money than we paid the people. But then with the worldwide economic situation that we're still wrestling with, that $60 million surplus was used up. Last 2 years, we're on the much improved track again. And that's why we just wanted to maintain it. People that have worked for the city for many years and are working toward that goal of entering the drop, we're trying to maintain that for them.
And I don't know if you've done this, you probably have. If you apply over the course of the time period, the range that's been stated by the city from, I think you said 92, but early 1990s through today, would the employee accrual rate have been higher than 8.4%?
I'll find that out.
Because it seems to me that what you said is there were years in which you actually had up to a $60 million excess because of actual performance over time. You accumulated it over time. So you pooled it, yes. So that was money that was pooled to the plan. And what you really did with that money is you turned around, and it's like the 7 good years and the 7 bad years. You turn around and use the excesses. So wouldn't actual performance have offset that anyway? Actual market performance?
Could have. I'm going to get you that answer. It's the first thing I tell you tomorrow when we get here.
I do think it's important that in looking historically, what I think the original scriveners did a little inarticulately was try to identify the actual rate of return, because they were trying to use the actuarial rate of return. So rather than try to guess that as the market moves, we've just placed that into the record with a cap. And to try to preserve, again, to pay the unfunded liability, because the people who presently have this number are contributing to the unfunded liability. The fund is subsidizing those lump sum drops, and to the detriment of the people who aren't in drop, who are retired.
Let's go to the employee contribution, see if we can start off with some things. Is everybody now in agreement that the employee contribution rate will go to 10% when there's a reinstatement of the employee salary rollback, or whatever the right term is?
No, I mean, that's not what this proposal, this proposal does not mean that in an employee's paycheck, the amount going toward pension goes from 7 to 10%. This might mean that through another source, effectively, if I'm interpreting what John's presenting correctly, there might be a contribution equal to the value of that increase. But this doesn't mean an employee's paycheck.
Then I misread the last paragraph down at the bottom.
Member contribution following return of wage reduction, 10%.
At the bottom.
So this is an and not an or.
That's correct.
Okay. So this is a little bit different than what you suggested yesterday.
Yeah. What I'm saying is, so I want to make sure that I'm trying to find things we agree on. As I read this from the bottom of your 513 proposal, and as I read what you have at the bottom of your proposal of last week and earlier this week, the employee contribution rate, the task force recommended 10%. You've agreed that 10% is the appropriate employee contribution rate. The task force recommended, and the city has recommended when it was restored, and you've agreed that that's what would happen, is that when it was restored, it would go to 10%.
Exactly as we agreed in Gainesville.
In the MSA.
Exactly.
All right. Go ahead, I'm sorry.
That's not what we agreed to. I mean, if it's exactly what we agreed to in Gainesville, then this is different than that. I just want to be clear.
No, the overall proposal, but not the 10% part, I don't think.
Well,
Am I wrong?
There was a different number. We agreed to an increase from 7 to 9 in Gainesville over sort of an attenuated period
Right.
of time. I just want to be clear, John, are you now agreeing that once the pay reductions are restricted, what we had proposed was an immediate increase from 7 to 8, and then once the pay cuts restored, from 8 to 10. Are you agreeing with that sort of bifurcated?
Because the way the increase was presented there, half of the future increases would go to the pension contribution until they reach 10%.
Okay, so I'm a little, are you agreeing to what, forget about what happened in Gainesville, are you agreeing to what we've proposed here in terms of the way the employee contribution would increase?
And you're proposing that it go,
Well, we proposed that upon implementation of an agreement, it would go from 7% to 8%, and then as soon as the 2% wage cuts are restored, it would then go to 10%. Is that what you're agreeing to?
that's a cleaner way of doing it. Yeah, I think that's acceptable.
Okay.
All right. I'm in the dark with a flashlight. I find some light
But
spots.
and again, just because I just want to have the record be as clear as possible, that would mean there would be that commensurate impact on paychecks. It wouldn't be that increase paid through some other source. It would impact paychecks.
Paychecks.
Okay.
All right. So I get that the employee contribution provision on both of these proposals overlaps, and I believe we have an agreement on the employee contribution. So let's go to the drop. And I just want to go back to this. I'm not saying, if there were some other movements by the city on some of these, is the board willing to accept, is the board willing to accept a change from the 8.4% to actual performance with a minimum and cap?
Potentially.
That's better than no.
John,
Go ahead.
what would make that a yes?
Would make what?
What would make your answer a yes rather than potential? I mean, we're trying to come to some closure on this, so you're saying potentially. So what are we missing, what are we leaving out that would make that a yes?
Well, obviously, they've got a financial proposal on the page.
Yeah,
Okay.
to leave these COLA benefits here and, final average compensation. But we were even going to have a proposal on the final average compensation when we get to that.
Let's talk about that then. I think the proposal that they had was that it would go to 60 months. I don't remember what we did. I don't think we did anything on that. We used the 60 months for the new employees. Their proposal is that we would go to 60 months, and I think theirs was, correct me if I'm wrong, their 60-month proposal kicked in for those who were, I take it the wrong way. I just want to make sure I got it exactly right.
Within 10 years.
It was the 60-month for those who had not achieved 10 years of service at the time we institute this, or whatever that date would be, but they would also be a lock-in by which that 60-month could not diminish them below what they would have had already accrued on a 24-month basis.
That's correct.
The 24-month number would be at the date of implementation.
That's correct, whatever that was. But that would be highly unlikely that would occur, but there's a scenario by which it could. But generally speaking, they're talking about 60 months being used as the final calculation figure for those who have, at the implementation date, have completed less than 10 years of service. You said you had some thoughts on on calculation rate. What are your thoughts on the calculation rate, John?
For the people with less than 10, rather than going to the 60, we would suggest a 50% increase and go to 36, from 24 to 36, for the people with less than 10 years. People with over 10 years, not going to be a change.
Right, well, there's not a change on,
Right.
on theirs either for
Right,
people
there's
more than
not.
10,
Right.
I've got that right, correct?
Right.
Okay.
So for the people with less than 10, instead of going from 24 months to 60, we would propose going from 24 months to the last 36 months.
So what you would have is you would have a situation by which you had people who were, you would have 60, that would be new employees, people who would have 36, that would be less than 10, and people who have 24, that would be people with more than 10.
Correct.
And their proposal, you would have
24,
60,
and 60 for the new people.
and 60 for the new people, correct. So the difference is, in yours is between 36 and theirs is 60. That would be your proposal. But you would be willing to move on some calculation of the final average compensation for those who have less than 10 years if it was part of a larger deal.
Right.
Same question back to COLA then for a minute. Their COLA proposal really had two tiers, for less than 10 and greater than 10. And tell me, is there a consideration on your part of a COLA provision that for persons less than 10 different than for the COLA provision for those who have greater than 10 years?
We haven't finalized our COLA recommendation.
Okay.
But we would say that it should be the Social Security maybe be better than that 1.5 because off in the future, with inflation return, some Social Security COLAs in the last 10 years have been 7-8%. And so, we wouldn't want to have these people hobble down here at 1.5. If we're going to use the Social Security, we ought to consider using it.
So your proposal on that is that your proposal would be to take a look at using the actual Social Security.
We're looking at that, and we're running some numbers they're running some numbers as I'm over here with y'all.
Okay. Is there an appetite at all for a different COLA between people who have less than 10 and those who have greater than 10 on the implementation date, which is a central component of their proposal as I see it?
I think that differences of how we propose to handle the people in this last proposal, should be uniform there.
Right.
Less than 10, it's going to be this way and this way. Over 10, this way and this way. But we're going to have that proposal for you, hopefully first thing tomorrow.
Chris, I'm going to kind of put it back on your side and kind of go through that same. On the employee contribution, which seems like we've been able to deal with, on the drop, explain to me the motivating factor again for why it is in the best interest, you believe, of the plan and in the plan design, and to leave that which has been the figure we've used since 25 years or something like that, or close to it, and going to an actual performance with a cap on.
Well, and Joey may want to expand on the finances of this, but the most financially prudent step to protect the funding status of the plan, make sure that it's financially sound, is to tie that interest rate to the actual performance of the plan as opposed to an arbitrary number, 8.4% going forward. So if you establish that floor of 0, which as Cindy has pointed out is a result of IRS rules, that's the lowest you can do, and a rate cap of 10, and take it to the actual rate of return from a financial soundness standpoint, that makes sure you limit the risk to the plan, but at the same time, allow the member to get the actual rate of return. So we think it's fair both to the member and financially sound for the plan.
Well, yes, and Joey, maybe you want to pitch in on this too. The cap at 10 was arrived at, I'm assuming this year performance is probably greater than 10.
But I mean,
either that or there's needs to be some changes made. But my point is, I'm sorry, didn't you?
And the reason for it is, remember, this is a safe harbor for employees. Employees are entitled to take their drop money and invest it themselves. So if they look at this is a very safe way to do it for people who don't want to manage it. But if they feel that the 10 cap is too low, then by all means, it's fine for them to take their money, take the risk out of the fund, because right now the fund is operating as an investment manager, which just is well beyond its charter. And so the employee does have the right, if they think 10 is too low, to take the money and use a product manager and develop it. So that's why this really was, I think we might be losing sight that this really was
I think
a
you're making
compromise
a good point. What you're
situation.
saying is, look, the 10 was a cap that we had, that we imposed, but there's nothing that prevents the employee from making their own investment decision. What do you think about that, John?
Well, the 8.4 came about at the time when the fund was making over 20, and the city mothers and fathers at the time said, we're not going to give them 20. And that's when they came up with using the actuarial assumed rate of return with a 10 basis points user fee, for example. That's where the 8.4 came from.
Okay.
Well, Ron, I should also point out the 0 to 10 range is exactly how the backdrop provision for new employees is designed. So there is some symmetry to that.
Yeah, that was the same numbers we used.
Exactly.
Go ahead.
However, a backdrop gives the employee a lot more options than a forward drop does. They can pick the time when they do it. If they get promoted, this and that,
Go to the higher side.
There's some advantages to the backdrop, which we agreed to offset with the range of 0 to 10.
Let me hear a little bit more from the city, your reaction now to the plan that's been put out in front of us guys. And Joey, you may want to, I know down in Gainesville, you had a lot to say about these respective kinds of ideas. Tell me about this particular proposal, what you consider its strengths and weaknesses.
I'll make one comment while we're talking about the drop, rate of return to guarantee rate.
Sure, okay, sorry.
When you talk about a range of 0 to 10, if you are going to put a floor at 0, I'm sure Cindy and Daryl and Chris can talk more about some of the legal thinking behind that. If you're going to put a floor at 0 and give them the actual rate of return on the plan, because you're not going to flow through any of the losses,
Right.
you want to put a cap on the upside too. So that was some of the thinking with the 0 to 10 range. You can't guarantee no losses and then just pay the total upside because the plan would be hard to define. The math just doesn't work.
And how do you react to the idea that the employee also has the ability, if they want the performance, if they believe the performance is inadequate, that they can individually make the same investment?
I think anybody at any time, after you leave the city, when you're in drop phase 2, you can take your money and go do what you want.
I know, we don't have the same type of drop plan that some places do, where the member can call up and say, today I want to be in
Right.
State Street Spiders, and tomorrow I want to be in something else. We don't have any of that
I
going
got
on.
that, right. I got that, but what they're
The member does
suggesting.
have the
We don't
ability to
have
pull their
that.
funding in the plan, even after they've.
They can take the money when they retire, or they can leave it.
Got it.
They
I
get
think
one
your
second
suggestion
choice.
was if your own investment plan could be more successful if you chose to take a little more risk on your individual.
Right, the trust has to be risk adverse, and individuals don't.
All right.
So along those lines,
go ahead. Yes, sir, I'm sorry.
There's no real difference in the two plans other than what we talked about yesterday in terms of asset allocation and the ability to use different products. But we may use more as joint employees than police and fire. But what you're talking about here is as it relates to investment, the fund managers are selecting those investments. The individual members are not. So again, at retirement, if you decide that you don't like what's going on there, in either plan, you take that money, you roll it over, and you deal with it yourself. But when it's in the plan, we talked about that yesterday, the investment managers, through our consultants, they're the ones that are deciding on what is bought in that actual retirement program, not the individual members of the plan. That's no different than any plan around the country. So if they want to be out of that, then you get a chance to go beyond whatever you want to do and try to earn what you can. So that whole idea is a part of this whole strategy. Investment returns is about a fourth of the ingredients that manage these plans, which is why we've always been talking about the benefit side of this plan is the unsustainable side. The investment side has been in that issue of how well are you doing, the folks that you're hiring and who's doing it, what are they doing? And we've had good returns in both the police return and in the general employees. So that's been on the upside, and it's been that way for the last 5 years. So we've benefited from that. But you're not going to have investments in that plan eliminate all of this negative risk that we're talking about as it relates to people having their money in it. What is the amount of contributions that we're going to make? Those are 3/4 of this whole apple that we're trying to carve up here. So investing is a portion of it.
I got it. Thank you. Go ahead.
So I want to, something I want to be clear about. The board is, and I know you and the board are appropriately very concerned about the funding level and trying to increase that from the low of 39% to one that's more healthy. So given that focus, the board is comfortable with establishing a share plan as of 10/1/14. I mean, they're confident that's a financially sound measure moving forward.
Absolutely.
Well, but
As I pointed out, there would not be funding in the initial year, but this is to have the vehicle in place.
what I make sure I understand this, that your rendition of the share plan, of the board's rendition of the share plan would be that even if the share plan were established, the other obligations, including any obligations agreed upon for unfunded liability reduction or employee benefit offset, those would come before there was any funding for so back to your point, the share plan's establishment wouldn't necessarily mean that the share plan was at any point in time in the near future of any value.
It wouldn't be funded until there was sufficient revenues to fund it.
Above the obligations that you've agreed to here,
Correct.
if we had agreement, those obligations being that you would fund the unfunded liability portion.
Correct.
And that you would, whatever the cost of the offsetting that you have proposed, or offsetting of what would otherwise be employee contributions.
Yes, sir. And to follow up on that, as we discussed yesterday, both the general employees and the police and fire have asked the city council on many occasions to increase investment options, and they have not done it. So when you have this vehicle going through here, like this new revised plan, putting something in that's going to be on the shelf and won't be used for some time off in the future, is a good time to hook it up to the train.
John, if this plan, if the city, if the city immediately said, we accept this team here, the mayor and the city's team said, we accept your proposal. Given the concerns that were stated by council at the last, when the MSA went before it for consideration, would this pass?
You're not funding it. It's a vehicle for future use.
I guess what I'm getting at, no, I'm talking about your proposal, not just that component of your proposal. Your proposal, and I know this is requiring conjecture, and I'm going to do the same thing on the other side, but what I'm getting at, if we assume that one of the major discussions, and you were there and you followed as closely as anybody, if one of the major discussions was some additional current employee offset,
Shared sacrifice.
Shared sacrifice, to use that term. Something, and the city had a plan, an MSA that was in front of them, and that plan did what you would have preferred to do on that issue, and that is it would not have affected current employees. And that was rejected because at least people verbalized, in part, that was the reason. Now, do you think your plan would pass? I just want to know. Is that a fair question? It may not be a fair question, but.
Well, you know, there's 19 members of the city council. And
First got it
as a longtime member of the Florida legislature, you know, you don't know until after the vote's taken.
same question, maybe equally unfair on your side. Yeah, go ahead.
Can we take a 15-minute break?
Sure.
Huddle up my team.
Yes.
Get them on some of this.
Take it.
Thank you.
Show us 15. Yes, and I didn't do well. Chris, let me go to, you actually brought out a new provision, 10.
Correct.
And I didn't go to that because I honestly, when it was all red line, and I looked at it, saw a bunch that was taken out, but I now see that you have a new provision.
Before we get to that, can I make a suggestion,
I do.
Senator? Because I think this would help with some progress.
Super.
So knowing that obviously we're not agreeing to relinquishing on the fifth member until we have full agreement
I got it.
on governance and current employees, but as a way to potentially help advance agreement on current employees, for the final average compensation period for employees who have less than 10 years of service. We propose 60 months, they propose 36. The city would agree to 48 if ABFPF would agree to that now.
Okay. I have a proposal is for 48. That's split between the two.
Acceptable.
Had a feeling that 48 was coming back. Because we've been doing this a long time. Okay, we got 48. Now,
We do it again.
can I go to, I want to go to the number 10 then for a second. Can I do that, Chris? Because I think we might be able to get this resolved. What I have, and I have looked at, and I want to, and I know, John, I'll give you a chance to respond. The way it reads as you've now produced it this afternoon is following the implementation of these benefit negotiations, the JPFPF shall not negotiate modifications to pension benefits and shall leave the negotiation and future modification of pension to elected city officials and certified bargaining agents. Nothing in this agreement shall be construed to impair the rights provided under Article 1, Section 6 of the Florida Constitution or Chapter 447 Florida statutes. John, I know that, first of all, why don't you react to that and give me what your reaction would be to the new proposed number 10?
Sounds like a very informed proposal to us.
Okay. Now, the language shall not negotiate modifications to pension benefits and shall leave the negotiation future is that acceptable to you?
Got to get that word negotiation out of there, and I'll leave it to the wordsmithing to find
Because your
some
position
alternate
is you
word.
don't negotiate and you haven't negotiated.
That's right. We're
How
not
about if I
negotiating.
use the word address?
Address, discuss, confer.
Shall not address modifications to pension benefits and shall leave the negotiation and future modification of pension benefits to the city officials and certified bargaining agents. Nothing in this agreement shall be construed to impair the rights provided under Article 1, Section 6 of the Florida Constitution. How's that?
And what was the word you're going to put in?
I proposed address.
Address.
I left negotiate in as negotiation as it relates to the bargaining agent in the city, but I just substituted the word address. I don't care. Address seemed to be.
What if we use the phrase, and Cindy, contingent on Cindy feeling comfortable with this, shall not engage in modifications to pension benefits and shall leave the determination of pension benefits to elected city officials and certified bargaining agents.
Take that word out and you say.
My only concern with engage in, I'll just throw this to you.
Sure.
Actually, they would implement what was negotiated by us, and I don't want to prevent that.
We also have to do the
Engage in
costing.
I mean,
John, what's your concern, since you say that you're not negotiating benefits now?
We're not.
What's your concern about?
Having good faith
using that
dialogue
word?
and friendly discussion.
I got you. So since,
We don't want to have this again. So what would
per
you
your
call it?
description, there's not a negotiation going on now, which word would you, why is negotiation objectionable? Since if that's not happening now, then why would you object to putting
I
that
think
in?
because the word negotiate in Florida law is a term of art that is a relationship between a public employer and a public employee organization.
Right.
And I don't want to get confused
Right,
in
we're
that.
saying you're not going to be doing that, not you, but the JPFPF is not going to be doing that in the future.
Negotiate, address. We don't negotiate, we definitely know that.
Well, then if you don't do
And
it,
if
then
you
you're
say
not
you're,
gonna do
if
it.
you say you're not gonna do it in the future, that doesn't necessarily mean you did it in the past, does it?
No, it does not.
Thank you for agreeing, Mayor. We're on the same team.
That's for sure. Well, what about, I mean, engage may actually do it because if we use negotiate, we don't want any implication that if we're not negotiating now, we can do this again. Because I don't think
Correct.
we-
No, that's a good
that's
point.
right.
Yeah.
So,
But as
so
long as we're
engage, I
all I'm
think,
concerned about is engage in the modifications. They will engage in modifications if there were to be,
they'll
if the city
implement,
and,
they'll implement.
okay, I
But
just
they
want to make
won't.
sure that that doesn't turn around and bite you.
Cindy, would you be comfortable with a language that said the PFBF shall not engage in the determination of pension benefits and shall leave the future determination of pension
Yes.
benefits? Would that work for you?
Yes,
Okay.
I think that,
You all right with that, John?
That's all right with me.
So we'll put, shall not
thank
uh,
you. It's true.
engage in the determination
Yes.
of pension benefits.
Because then it's clear. you
They,
do
that
all
would
that
make it,
stuff.
nobody
Yeah.
later can say, well, you can't modify something.
Right.
It just makes it clear
It's got it.
that the
They're not
subject
gonna-
of what the pension benefits are
It's not there.
is not, the JPPF is out of that.
I got that. All right, with that, then,
Let's get this, would you have to read it back? You gonna read it to us?
yeah, I'm going to read it back and see if I have it right, okay? Following the implementation of these benefit modifications, the JPFF shall not engage in determining, or in the determination, excuse me, of pension benefits, and then the rest of it is just written.
Well, and shall leave the future determination.
No, the rest of it is just written.
Oh, as written, I see.
As written, the rest of it as written. That's the only thing we changed from that.
Gotcha. And just so it's clear for the record, this would mean that the police and fire pension fund is out of the pension determination business, because this then provides how benefits would be provided, determined into the future.
I'm not going to say what it does, I'm going to say what the language is. The language is shall not determine, shall not engage in the determination of pension benefits, and the rest of the language as was previously read into this record and is in your proposal.
Okay.
All right? Now, with that, guys, I want to go back and see if I have it right.
And while we're on that,
Sorry.
since we're kind of on the back end, John, do you have any objection to the changes that were made to 11 and 12 in the governance provision? 11 just simply removed 2014 per your suggestion, and added the sentence at the end about meetings being in accordance with applicable federal, state, and local laws. And then 12 just simply modified, the language of recommendations of the task force to what the city and the JPFPF would do to implement any agreement.
So the 2014, taking that out, John, that was your
Yeah.
suggestion.
That looks all right to me.
Okay?
So that's good on 11 and 12.
That's 10, 11, and 12, right?
Gotcha.
10, 11, and 12. All right, actually, so that we're accurate now, see if I'm right. We now have agreement on 1, 2, 3,
Each of them.
4, in the sense that if we otherwise reach agreement, 4 is withdrawn.
Correct.
5, if we reach agreement, and on 4, the language of 5 is acceptable. 6, which has been done. 7, which is done. 8, which is done. 10, which is agreed to. 11, which is agreed to. 12, which is agreed to, and 13 is withdrawn. 9, we haven't addressed, and we will not address until we get to the very end, although there is 9. There's a provision of 9, paragraph 6, which is agreed to, that is the monitoring by the now, as I've been corrected, former magistrate and now current federal judge. Please make sure that I show that deference, should I ever find myself there.
Now, all of 7 wasn't agreed to.
I'm
I don't
sorry.
believe.
Tell me where we had a difference on 7, then. Don't want to go ahead. I thought we had 7.
And just before we get to 7, let me just clarify. So 1 is done, 2 is agreed to, 6 is agreed to.
3 is agreed to.
3 being the language that the moderator proposed this afternoon is agreed to. 4, you just summarized that. 5 is obviously tied to 4. John said to sort of hold on 7, but 8, 10, 11, and 12 are agreed to. Is that correct?
I thought so, but I may be wrong. Let's go back to 7 and 8 and look at those again, John. Let's try to get those done. We're on 7.
7 is fine, it's 8 that
Okay, so
we haven't
7 is
decided.
okay.
7 is okay.
All right, so we're down to 8.
Right.
All right, let's go to 8, and the floor is yours to see if we can get governance, realizing that it's linked to everything else, but this would get all of the governance.
It's where the incumbent's going to go on August the 15th.
There's been suggestions on where the incumbent could go.
There's been many of them over the years,
Okay.
I'd like to
Tell me what
report
your
to you.
suggestion is.
Most of them didn't have a roadmap.
We're not telling the incumbent to go anywhere. This
Tell
is clear.
me where, how you want to fix it.
Well, we're going to shut down, it's proposed to shut down the senior management pension fund.
Okay,
And in several lines above, we recommend that future administrators be placed in the general employees or 401A type of plan. So that just leaves the incumbent of what, is he going to go in that plan? A 401A plan?
well, it doesn't say, it says, or a defined contribution plan.
Or either one, either
Yeah,
way.
that's what it says, which I think you've agreed with, a
The-
401.
Since we're all talking about third person, the city hasn't yet defined where the incumbent would go under this scenario. I don't think this addresses that specifically. It addresses a future
Future,
incumbent,
yeah.
but not the current incumbent.
Well, theoretically, where would the current incumbent go?
Well, let's ask Mayor Brown, because he's running for election, and he would probably give me a better answer than some of the other people.
He's a different kind of incumbent.
Where would the incumbent
Yeah.
like to go?
Where would you like to go?
Let's go to church.
Amen.
I mean, I guess what I would say, John, is it might be helpful if you were to come back with a,
Tell
we may
us.
not be able to determine that today.
Tell us.
Okay.
What a suggestion
Okay,
would be on
sure.
where the incumbent.
We're actually
should
talking about
go.
one spot here, folks.
Right, yeah.
Other than that, is 7 agreeable?
Well, let's,
8, you mean.
8, I'm sorry, 8, I'm looking right at it.
well, why don't we just say right now, shall assure that the incumbent and any future administrator, senior management employee shall be placed in the general employees pension fund or the, just put the incumbent right in there
Well,
right now.
there's one technical question that we need to, I need to just kind of check with Joanne on that. So we just sort of hold that while we,
Okay.
because there's a number we got to
Sure.
look
Hold
up.
on a second. That's your proposal.
That's his proposal. We just need to check something.
Could you say that
Say that
proposal
one more
again
time.
for the court reporter so she can get this so that I can write it in also? Go back and, your proposed language, and then that'll be what you guys will look at.
We'll look at, correct.
It's 1, 2, 3, 4, 5, it's the middle of the 6th line. The city and/or the JPFPF shall assure that the incumbent and any future administrator and/or senior management employee shall be placed in the city general employees pension fund or a 401A is the number, right? 401A plan to be established by the board. And you had some words earlier, Chief Hand, about the maximum federal contribution. All that has to be worked into that.
That's in the number 8 here. where it
Yeah,
talks
well,
about the word-
I'm operating off the original one.
Oh, I
Yeah,
see.
or a
And you're
defined
able-
contribution plan with the JPF,
Oh.
subject to the limits of federal
It's on
law.
this one here too? Oh, yeah.
The red line version.
Oh, in that
That's
case,
different.
yeah.
So your proposal, which we'll review with these technical review we need to do, would be adding the incumbent to what would go into the,
It would say the following.
right,
After the word "that" and before the word "future" would be that the incumbent and any future. Correct?
Correct.
Okay, that's the proposed language, that the incumbent
And
and then it picks up any future. All right? Now, if that language were to be acceptable to the city and they could work, is there anything else between numbers 1 through 12 not agreed to except 9, which I am not addressing on purpose right now?
Well, and 4 and 5.
4 and 5
Right.
are, I'm saying I realize all of these are determined by our being able to work out the remainder, but as to any language, have we now agreed to the language of numbers 1 through 12? Realizing that 4 and 5 are tied into other acceptances, et cetera. But
And 8 now, we're leaving 8 still,
8,
because they're gonna have somebody check it.
they're going to check into it. But if that were acceptable, is my predicate. If that were acceptable, do we have the language agreed to on numbers 1 through 12, excluding 9, and realizing there is no longer a 13?
4 and 5, you keep forgetting them.
No. I thought of it. 4 and 5, I'm just talking about the language on 4 and 5, realizing the city is tying that to other agreements. We understand that. But if these other agreements should be reached, 1 through 12, excluding 9, including 4 and 5, realizing the reservations you have to fulfill, but I'm talking about if the other agreements, have we got the language that would be the governance section completed?
Yes, sir.
I think that, though, the confusion is 4 would be removed, so we wouldn't be agreeing on
4
language.
would be out.
Right.
Yes.
Okay, so that's,
Yeah,
hence we're
that's
agreeing
correct.
on the deletion.
4 would be out, yes.
Yes, if
And we would,
everything else is.
and ultimately, we will renumber these in the
Yes.
order we get them done, I understand. 4 would be out, 5 would be adjusted in a light of 4 being omitted is all that happens, okay?
Yes, okay.
Now, with that, what I suggest to you guys now is that we go back, and what I propose, and see if this makes any sense to you. I want to go back to the city's proposal for a moment on current modifications. On the current modifications, we've now agreed to the silo that is the employee contribution. Is that correct from the city's point of view?
Correct.
Number 4, that's agreed from John's point of view. Number 4, we are now on the drop. We're dealing with whether or not it would be the 8.4 or the, but we have also, to be clear on this, we've now agreed to the final average compensation moving to, for those who have less than 10 years of service, would now move to 48. That's done.
Yes.
All right. Now, what we have in front of us is the drop, which is the issue of whether or not the 8.4 could be a range of 0 to 10, as the discussion already was, and then the COLA. 2 questions: the COLA amount, and whether or not there'd be a differentiation after and before 10 years of service. You have made a proposal, John, that has a significant financial component to it. What I'd like to do now, and see if this is agreeable to you guys, when I start discussing this, and when we all started discussing it, it seemed to me that we also began to talk about the issue of unfunded liability, because it is intertwined. Am I wrong that unfunded liability becomes somewhat intertwined with the level of contribution that has been proposed? Meaning, you guys have proposed, I think you gave a number a minute ago of an additional $62 million that would be out of chapter funds over a period of time. I understand that. But was that the number you gave?
The number's the number.
Okay, the number's the number. You guys have a proposal for $40 million and 4.5 on unfunded liability. They have a proposal for a shared plan, realizing that the unfunded liability and any other amounts have to be paid before any money would go into the shared plan. So the establishment of the shared plan does not constitute the funding of the shared plan, correct?
Correct.
All right. We have the unfunded liability proposal that they've made. It is $40 million to be matched by $4.5 million from you, and you have a response to that, which was an expanded authority for investment, right? Are you going to have any more proposals on the unfunded liability other than the proposal that they have made and your return, which is not an acceptance, and your response back, which was for expanded authority? Do you have other unfunded liability, or is that inherent in that which you have advanced today as your new money, so to speak?
Yes, we're going to come up with another proposal for tomorrow.
All right. Do you have any further reaction to the COLA today as it relates to their proposal, which that the COLA be capped at 1.5%, and that the difference in the COLA be for 10 years or not is the use of age 55? I mean, I know I'm cutting it short, but basically, if you have more than 10, you get it when you get it. If you have less than 10, your COLA wouldn't be something you would take before you had reached 55. That's the difference.
55 before you could start benefiting from the COLA.
That's right. That's the difference between the 10-year draw,
Correct,
as you've drawn it up. You agree, you've proposed 1.5 for the amount, and I'm assuming from your response,
The lesser of 1.5 or the social, or
the
CBA.
lesser of 1.5 for the Social Security
COLA.
COLA.
Right.
You've come back and said you prefer the actual Social Security COLA, which that's their proposal is you understand that the Social Security COLA is only used if it's the larger number. If not, it's capped at 1.5. The only time it would be was if the COLA was lower for Social Security.
Well, we discussed that, but that's not our proposal.
No, I got it. I got that. What do you have to say about COLA? We've addressed, we know what the drop issue is. The drop issue is whether or not we're going to have the range of the 8.4%. You currently favor the 8.4. They want the 0 to 10%. You have not said inalterably no, but you said you're having your people calculate how that would have performed.
Right.
Where are we on the COLA, John? And where are we, from the city's perspective, on the COLA?
Well, we've made our proposal.
That's your proposal.
So we're waiting on a response.
We're going to send a response tomorrow.
Okay. All right. Do we have anything today left? We've got the governance language. For the record, I understand the language is pending all agreements. The language is there. We have not reached an agreement on the current employees, the unfunded liability, and on the current employees where we are is we haven't reached a proposal on drop and on COLA, but we have reached for FAC for 10 years, for less than 10, and we have for employee contribution rising to 10 with reinstatement of the money. Correct? Reinstatement of the rollback.
The cuts, correct.
Yes. Okay. Anything else that you have for today, John?
No, sir.
So it sounds like, and just so I'm clear, John, you'll come back tomorrow with a counterproposal on COLA, a counterproposal on drop, and some sort of counterproposal on unfunded liability. Now, just to be clear from our perspective, as we said in our presentation, the city has made clear it is a prerequisite before we agree to put additional money in that we have agreement on new employees, which we have, current employees, and governance.
Got it?
Yeah.
No, nobody's trying to.
Yeah.
I'm just saying we're not going to go back and revisit the language.
Right.
If we get an
Gotcha.
agreement on the other subjects. The language on governance has been agreed to if we reach the other agreements.
Gotcha.
All right. Anything else to the good of the order today? We're set for 1:30 tomorrow?
1:30 p.m.
1:30 tomorrow. Guys, the plan is we've got tomorrow, and there's no lock on how long we can go, and we've got Thursday, and then I'm unavailable for a good while, and I'm certainly replaceable, but I don't know anybody else can step in at this point in time. So let's get this thing done. We've moved a long way. We have unfunded liability, which you've made a proposal on, and you have a counter proposal as it related to its expanded authority. You're going to have some additional drop for current employees and COLA for current employees. Are those all the differences that we have now pending?
I believe you captured it completely.
Yes.
That's it for today,
Thank
folks.
you.
Thank you.
Thank you, Mr. Brown.
You're going to announce the adjournment.